Hey, Rick McBride here with your Property Masters in 5 minutes of free time. Your daily dose of real estate education. Today I want to pick up where we left off on the contract, which is the Florida Association of Realtors as-is residential contract for sale and purchase, approved by the Florida Bar. And we are on section 15, and it is default and dispute resolution, which usually happens when property doesn't close. That's when we run into this situation. But default by the buyer is defined as if the buyer fails, neglects, or refuses to perform buyer's obligations under this contract, including payment of deposit within the time specified. Seller may elect to recover and retain the deposit for the account of seller as agreed upon liquidated damages, consideration for execution of this contract, and in full settlement of any claims, whereupon buyer and seller will then be relieved of any obligations to the contract. At the seller's option, they may proceed in equity to enforce the seller's rights under the contract, which means they can go ahead and stay in contract. The portion of the deposit, if any, paid to the listing broker by the buyer shall be split equally between the listing broker and the cooperating broker. So if the broker's retaining half of the retained deposit or something, then he has to split that half with the cooperating broker. However, the broker's share shall not be greater than the commission of the listing broker had agreed upon to the cooperating broker. So basically what this paragraph says is that the buyer defaults, the seller can come after their deposit. If the seller defaults, if for any reason other than failure of seller to make seller's title marketable after reasonable diligent effort, so if he has a cloud on the title and he just can't market the title, then he's free and clear. Otherwise, it's considered default. The seller fails or neglects or refuses to perform the seller's obligations under this contract, so they say, you know what, I'm not selling after all. The buyer can receive their deposit back, waiving any action for damages if they accept their deposit back, or or they may seek to recover such damages or seek specific performance. So they can get their deposit back, they can sue for damages, or they can sue for performance, make the seller sell the property. And this paragraph, paragraph 15, the default paragraph, survives closing or termination of this contract. So that's good if it's later determined that someone was in default. In dispute resolution, unresolved controversies, claims, and other matters in question between the buyer and seller arising out of this contract or its breach, enforcement, or interpretation will be settled as follows. So as soon as someone raises a conflict, the buyer and seller have 10 days after the conflict is identified to attempt to resolve the dispute. If they don't, then they submit the dispute to mediation. The buyer and seller should attempt to settle the dispute, but if they can't, then they proceed to mediation pursuant to the Florida rules for certified and court-appointed mediators. So they hire a mediator together, ironically, when they're in a dispute. The mediator must be certified and have experience in the real estate industry. Injunctive relief may be sought. Disputes not settled by the mediation, so if they go to mediation and still don't settle, will result in court action and court jurisdiction. And this paragraph also survives closing and termination of this contract. The fees, the parties shall split equally any mediation fee incurred in any mediation permitted by this contract. So the ironic part of this is you got the buyer and seller arguing over some particular item, and now they have to cooperate and pick a mediator together and then pay the mediator. Each party will pay their own costs, including expenses and fees. So if they hire their own attorney and if there's any expenses they incur, they will pay it. And any litigation, and the prevailing party shall be entitled to recover from the non-prevailing party costs and fees, including reasonable attorney fees. So you pay for your fees up front, and if you win, you're good, you can collect from the other person. And if you lose, you can't. Good luck collecting, but that's what the contract says. incurred in conducting the litigation. Paragraph 17, this paragraph will also survive the termination of the contract. So basically, when we have a dispute, if the buyer's in default, the seller can try to collect the deposit as liquidated damages if they can prove the default. If the seller's in default, if they decide not to close for any reason other than non-marketable title, if there's clout on their title, they can't help that. The dispute resolution is they have 10 days to work it out together, or go to a mediator. The mediator's cost is split, and then the cost of the winner gets to collect the cost from the loser of their reasonable costs. The better way is to have everybody do everything and perform, and then everything runs a lot smoother. Want to get into a contract? You get into disputes and problems and resolutions, you need an experienced team on your side. We are that team. Your Property Masters. Contact us at 386-866-1007. We are happy to help you get top dollar for your property or business.